can I sue the U.S. government for processing delays and what to expect and what this process is about? That's going to be the topic today. My name is Sam Shihab, and with me,
Brian Burke.
We practice immigration law throughout the U.S. and throughout the world. We do employment immigration and family immigration. And as a matter of fact, this topic is a perfect lead to both areas of practice. We have successfully sued the government in both types of disciplines, both immigration, employment-based and family-based. And it's an opportunity to discuss it. We're getting a lot of inquiry about it. Government has been incredibly delayed. We're going to talk about what's the legal basis for it, what's the process, what to expect, Brian.
Yeah.
So the process, what is the process called, the delay lawsuit called?
Well, in my brain, there's two, legal actions that can come out there. It might be called a mandamus action, or it might be called an Administrative Procedures Act action. But essentially, lost my microphone there. They lead to the same thing. It's basically a court case where you say the government is not doing its job in a timely manner. So, hey, government, please do your job properly.
Oftentimes, we get people coming to us and say, as a matter of fact, I think I've had 3 phone calls today about, hey, it's taking too long.
Yeah.
What can I do? Can I pay an expedite fee? Can I pay an extra money to get the government to move the paperwork along? My father-in-law is stuck outside the country. My mother-in-law is here. Now they're separated, and I need them to be together because she's driving us crazy at home. And
she's driving him crazy,
She needs her husband. Yeah. Or I've been separated from my wife for now 2.5 years. We only had the wedding, and I couldn't bring her, and they're not responding to our inquiry. Or I filed my adjustment of status, and they approved so many people ahead of me. I was in EB2. They approved so many EB3 ahead of me, and now it's current, and now I'm jumping up and down trying to get people's attention, and nobody is interested in listening to me. Yeah. What shall I do? And we say delay lawsuit.
Yeah. So maybe we'll talk about the basic, sort of process, what a lawsuit looks like. So if you're suing to have your immigration case or to move your immigration case due to delay by the government, you are suing the U.S. government. Who are you going to be suing? You're going to be suing, the head of the Department of Homeland Security and a couple other people who are ultimately responsible for.
So the plaintiff
is you individually,
and then the defendant.
Going to be, the Attorney General and the head of the Department of Homeland Security, those who are responsible for, adjudicating immigration matters.
And if it is something has to do with the consulate delay, then you
Department of State for the consulate.
And you can throw in the ambassador of that country for good measure as a defendant.
Yeah. Point is, though, you're suing the U.S. government. All those folks that are coming under the umbrella of the United States government. Those are who you're suing. So basically, any court case from the plaintiff's side is going to start with a complaint. It's going to be a legally drafted summary of your grievance against the other party, your other party being the government. When it comes to suing the government, they have a pretty wide berth in terms of time they have to respond to that complaint, 60 days.
So what's in a complaint, Brian?
Well, it's basically a summary of, why am I complaining? Executive summary. It's, here's the law under which, I am coming to the court to basically complain that the government is not moving fast enough. And additionally, what's going to go in there is, the reason why it matters. Obviously, behind every delay case, there's people. And, in the case of, the mother-in-law and the father-in-law that are separated, that's going to be telling a story of why it hurts us to be separated. Why it hurts the plaintiff to be separated from their family members. What harm is it actually doing? Because obviously, the government always has to do its job, but the case is more compelling to the person who's going to hear it, a judge, if you have, a reason behind it, something that matters. How are you being hurt by the government not doing their job?
So also, I mean, a complaint is a legal term.
Yeah.
Not I'm complaining. It's a legal term, and there are certain requirements in it. One is why this court is the appropriate court to hear my client grievance.
Why not another court elsewhere in the country? Like, we're in the Southern District of Ohio here. Why not in the Northern District of Ohio, or the District of the District Court for the District of Columbia? All these,
right?
Because there's a network of federal courts all around the country that could potentially, hear
bring
this
the suit.
Yeah.
So, but there is an ideal one. There's more than one typically that you can bring it, and you can just explain why legally this is the appropriate court to listen to this complaint. Then what are the facts giving rise to my grievance? What are the laws in support of my grievance? And then what remedy?
Yeah, what would you like the court to do about all of, your grievance, essentially?
Yeah, requesting, what relief are you requesting from the court to grant you?
Yeah, and that's going to be something in a delay case. It's going to be, order the, consulate in Dubai to make a final decision, interview my loved one and make a decision on this case.
Yeah. All complaints are enumerated. Start with number 1 and ends with whatever number you're done, and you can break it down, and has all kind of heading and subheadings in it, and that's kind of on a structure.
Yeah.
From a practical standpoint, it tells a story. It has to have a story where it talks about the consequence to your life. This delay, what has it done to you? It has to read where if somebody reads it, they're going to say, "Oh my goodness, this is so unfair."
Yeah, for my wife, it's stopping us from starting a family together. It's causing me a ton of stress and anxiety. It's causing me a ton of cost to have to go travel back and forth between United States and Brazil, where she lives, so I can have any sense of normalcy with my loved one.
So you go into the court and you go to the what office? The clerk.
Yeah. Well, practically speaking, anymore, you don't even really do that.
Electronically, yeah.
Yeah, all these things are done electronically. Basically, you write up your complaint, you decide you have it done, and you go through the clerk to have that complaint served against the government. Essentially, part of the process of suing anybody is making sure that they get appropriately notified. So basically, you end up sending it to government attorneys as well as the individuals you're actually suing on behalf of the government.
And that's what we call service of process.
Service of process.
So we have to legally notify the Secretary of State, Secretary of Homeland Security. If you're suing the director of USCIS, you need to mention him in name and send him a notice, legal notice. And so now you've perfected the complaint by serving the other party, and that's basically the boring nuts and bolts of the process. And then once service of process is given and acknowledged, a clock begins.
Yeah. So essentially, every time there's a case in court, it's the interest of the court and obviously the interest of the parties as well to keep it, moving along. So basically, anytime you file something in court, there's usually a deadline, to either do it or respond to it. And when it comes time, once service has been effected against the government, a ticking clock for them of 60 days begins, in which they have to file an answer to your complaint. And an answer, you described a complaint in which the government, you list out, every sort of fact and law, that is relevant to your case. My name is John Doe. I'm a citizen of the United States. I'm married to Jane Doe. Here's the entire details of our case enumerated. The obligation of the other party in this suing the government or any court case is to respond to everything you've said in that lawsuit. I agree, I deny, here's what our position is in response. 60 days again.
So they get 60 days.
Yeah.
Okay. And then what happens now? Circling back to our delay lawsuit, Brian, What happens, what we see normally happen in those 60 days?
So there's a whole lot more that can potentially happen in a lawsuit, but as a practical matter, when it comes to delay lawsuits, fingers crossed, you're not going to get to that point where the government has to file an answer in your court case. Typically, what we'll hear is from a U.S. attorney, a government attorney, stating, "Hey, I got your complaint here. I've taken it, and what they might say depends upon, what their feelings are. But fundamentally, if you've put together a reasonable complaint and clearly articulated that you've been waiting for a long amount of time, the government attorney that receives that complaint, that's perfectly served complaint, they have two options. They can come back and file that answer, or they can try to negotiate and resolve the matter before they have to do the work of filing a court case. And really, if you're looking for a decision in your delay lawsuit, the only answer that you want is, hey, we're going to schedule your spouse for an interview, or we're going to make a decision on the case within 30 days. So typically, you either get an email or a call from this government attorney says, hey, here's what I think we can do to resolve this lawsuit on what, on this time frame. Would you be willing to extend my deadline to file an answer in this matter until date X, so we can, hopefully resolve this without everybody having to do a bunch of work.
So for the first time, we receive communication from the government trying to resolve the case and towards the approval.
Yeah.
Hopefully, in most cases.
Whatever you're asking for.
Yeah. So the complaint doesn't ask for the court to make a decision on the case. The complaint asks the court to force the government to make a decision on the case. And that's what the judge has to do. He will typically would give the government time, some time to say, you get, 60 days, you got some, what's your excuse? But it doesn't usually get to the judge because we normally resolve it before that. When they come around and say, hey, we think we can get this thing resolved in the next 45 days or 90 days because A, B, C, would you be willing to do this for me?
Yeah.
Give me extension of time so I don't have to work extra, and I'll in return get this thing resolved for you.
Yeah.
Which is wonderful news for the client because we always work at the level of the court with the other attorney. We work very cooperatively with each other because they are very sympathetic to us, most of them. Not all of them, but most of them are. They understand that the USCIS or the Department of State has delayed the case significantly, and they read the facts of the case, and they are really emotionally on our side. They don't like what they see.
Yeah, well, I won't even read it from that perspective. You're right. The attorneys we deal with on the government side are usually, pleasant to work with and understanding of why we've gotten to this point. But fundamentally, I imagine them not wanting to have to defend the government on these matters in court because, when I've been waiting for an interview from my spouse for, 2 years, I don't think the government can really, in good faith, defend themselves on a lot of these cases in court. Yeah. There's got to be the rare case where they have some sort of, compelling national security concern that they're investigating. They think, so-and-so is a bad person. But not all, but, is there any reason why, why you're making this guy wait for 2 years for a visa interview for his wife? We're really busy. Well, too bad.
By the way, Your Honor, we paid the full fee for 2.5 years. And by the way, based on the data that we have collected from their own reports, it takes only 3.5 hours to process a case. Yeah. We will cite also sometime data they release on what it takes to approve an adjustment. What it takes to process an EAD.
Yeah. So you referenced 3.5 hours. So if you look at in terms of the I-45 adjustment of status case, it's somewhere in the government policy that it typically takes them about 3.5 hours to,
for example,
to adjudicate one of those cases.
I think it's 80 minutes if I remember last time from the adjustment status.
Yeah. So this is what goes into a complaint. Aside from is this really hurting us? It's hey, the government says in their own policy that it takes 80 minutes to take care of one of these cases,
and we
paid $1,225, and it's been now 2 years. You need to find 80 minutes over the course of 2 years. Enough is enough. There you go.
Yeah, we paid basically $1.50. $15 per minute to get them to do their job. And they're not doing their job. And usually a judge who is appointed for life, federal judge is appointed for life, they're not subject to political wind or influence, typically would sometime be upset. And then he'll turn around, and they don't want to get in a situation where the judge order USCIS to do something, because now that is going to be negative publicity, and that's going to encourage more litigation. So they would rather resolve it quickly and amicably, which is the right thing to do because the case needs to be approved. So that's really what so what is the law, Brian? What's the law that you use? The one that we cite the most, that is a kind of a something that's
I'll put it up on the screen here. I would just, this kind of relates to the question is, when does it become a possibility that maybe I should sue? And, I think for me, the minimum baseline is this little quote from the law that's up here on the screen right now. This is 8 USC 1571B, and this is a policy. It is a sense of Congress that processing of an immigration benefit application should be completed no later than 180 days after the initial filing of the application, except that a petition for a non-immigrant visa under yada, yada, yada should be processed no later than 30 days from the filing of this application.
So, interestingly, the processing time right now for an I-130 in some of the service centers is running 36 months right now. 18 months to 36 months. 3 times the intent of Congress to 9 times the intent of Congress.
That being an immigration benefit application. And I regularly tell people, I-130 for your spouse, you're looking at, probably a year and a quarter to see that approved. Just the I-130, itself.
If you're lucky, because some of them are posting 36 months right now, Brian.
So that's, So I mean, all this sort of, to me, relates to the question of, how do I know it's the right, time to sue? So for me, that sort of sets my, my bare minimum. If there's law out there that says 180 days for immigration benefits, I think, it's probably, the government wouldn't consider it reasonable to go pursue them before that.
And if you go in before a judge and it's 190 days, 210 days, okay, well, it's within that 180 day plus or minus. But when you go to the government and at the time is 5 times, 4 times, 6 times the intent of Congress, it's very difficult for the government to defend it.
I mean, when I think about these, and I talk with people about this, it's finding that right time. The common topic that comes up is, well, what about post at normal USCIS processing times? If everybody else is in the same boat as I am, what's the chances of me moving my case to the top? And that's something I think is a reasonable, to a certain point. There's a reasonable argument from the government. Everybody is in the same position as the plaintiff here. We're just doing the best we can. But for me, eventually you get to a point where processing times be damned. It's unreasonable to take this long. And part of what I did, pursuing for this presentation is looked at employment-based adjustment of status processing times. I talked to a gentleman last week, Sam, may well be in our audience right now. He said that, I filed an employment-based adjustment in April 2021. My priority date's has been current the entire time, and they still haven't approved my case. That's 2.5 years of unprocessed I-485. The normal processing time for an employment-based green card application in Atlanta, 32 months. Ridiculous. Dallas, Texas, 27.5 months. New York, 23.5 months. Nebraska Service Center, 30.5 months. Texas Service Center, 37.5 months.
All these timelines are almost double the intent of Congress.
Well, they're way past. I mean, the intent of Congress, for the law is 180
days. 6 months. For more than double.
Be beyond
4 times.
Yeah.
4 times.
And when I hear waiting for a 2 years for another process of green card application, I'm sorry, enough is enough for me. I'm pretty differential. I always try to warn people that it's going to take a lot of time to process these things because government processing times are long. But I think you just hit a certain point where it is ridiculous, the processing times that they are posting out there.
I mean, part of the problem also is mismanagement. The government is in a massive mismanagement problem. Last time I checked, more than half of the workforce have not come back to work yet. They're working remotely.
Yeah.
I don't know why. I don't know why a government employee is working remotely. It doesn't make any sense.
Well, I don't know. Can they work efficiently remotely?
Look at the processing time, Brian.
Well, you're right. I was looking up these numbers. I was just spending some time just sort of spinning the wheel of USCIS processing times in offices. Here in Columbus, they say it's 9 months for an employment-based adjustment, which isn't too shabby. But I don't see how they, Atlanta is, I guess it's probably maybe a little bit bigger than Columbus, but 32 months. Ridiculous. Absolutely ridiculous. Denver, Colorado, I looked up, 30 months.
It's outrageous.
Outrageous. And I mean, if you're content to wait that long, I suppose you can, but more than 2 years, that's when I'm just good.
I mean, if you're dealing with consulates, the backlog is atrocious. I mean, multiple years to get an interview sometimes.
Yeah, no, I'm repeatedly hearing that lately relating to Lagos, Nigeria, which is a big, huge, U.S. consular presence there. A lot of countries from around there funnel their cases into Nigeria, and years to get consulate interviews. Ridiculous.
Yep. So that's anything else to add, Brian?
Well, so I guess the point on that is 6 months on anything immigrant related is where you can really maybe start thinking about it. But fundamentally, I don't know. It's just kind of a balancing test of factors. I think.
What about those that say the government is going to retaliate against me?
Oh no. You can say a lot of things about the U.S. civil service. Mostly they're very, 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 very slow. Very slow, but they are not. You cannot bribe. They're honest. You cannot bribe them. You cannot, piss them off. There are systems in which an eye is generally kept upon people, and they can't not do their job. And that's what courts are for. If it's found that the government is acting, if they make bad decisions based upon gut rather than facts and law. That's when, another type of court case.
Have you ever seen a single incident in which the government retaliated?
No, and I don't think you're going to find
single one.
Yeah, a single one out there, because frankly, when you sue them, they're under more scrutiny. Those folks don't want to be the government officers, the civil servants who process cases. They don't want to be under the scrutiny of a government lawyer, let alone a government lawyer who has to deal with the second lawsuit. So you got so irritated that somebody dared sue you that you took it upon yourself to act outside the law. It seems like a great way to lose your government job.
Right.
Yeah.
So that's really not on the table.
Yeah.
So that's delay lawsuit. A lot of people calling about delay lawsuit. There's a lot going on in that area.
Yeah, maybe we'll get some questions, because there's all sorts of interesting factors to think about when, especially say it's a green card related one. Is my priority date current? Has it been current the entire time? That sort of thing. Yeah.
Yep.
So maybe we take a pause here and take some questions.
Sounds good. So this is the time when we remind you that please don't make a decision on your case listening to us. Hire an attorney of your choice to help you make a decision on your case. We don't know enough about your case to really be comprehensive. We're just basically whetting your appetite with some bits and pieces of information and sharing some information from our knowledge, and also learning from you. We get a lot of good information from you guys about what you're seeing out there as well. And obviously there's no attorney-client relationship established because we're having this YouTube session and answering virtually online.
Yeah, it's out here in public too, so the answers to your questions, don't put anything in the chat you wouldn't
want the world to know about. Because one topic we want to talk about soon is how important social media is to your case.
Yeah.
But we can talk about that later. Let's answer the first question. From Explorer Dreamer.
And I'm going to make this bigger so we can stand a chance of reading it here as we go.
I have a 485 pending with priority date 2014, October. I have 5-year advance parole. Can I get to India and stay for 4 years? When the final action date is close to my priority date, I will return to USA.
There we are. Since 2014 October, it's going to take 3 to 4 years. My I-45, will it be valid and 485 rejection is expected, or should I exchange the consular processing in India? Continued. Since the Sam, I realize I took over. I'm sorry.
No, that's good.
Since the I-140, 45 all related to future job, I will produce a new I-45J after 4 years of my return. Will it create for my I-45 problems? I imagine. I'm planning on staying outside the United States for 4 years.
He already triggered a lot of me thinking. I start thinking about his question because he's asking a fantastic question that probably deserves a whole session about what does this 5-year advanced parole mean, and does it mean that he can leave for 4 years and come back?
Yeah.
Is there a job opportunity that is not available anymore? Or should we switch to consular processing, which is, all those are fantastic questions.
Yeah.
Wow. But those are real practical ones. So let's talk about strictly the law, and then we throw in the common sense layer on top.
Yeah. So strictly the law, that I-45, the I-140 application and the I-45 that comes with it are about a future position. It's about availability of a permanent position for you when a green card is in your hand. There's no requirement that a green card applicant, an employment-based or family-based one, have ever stepped foot in the United States before. It's relatively rare, but I've done plenty of green card cases for employment-based ones. People never stepped foot in the United States before.
Never ever before they got their approval at the consulate.
They enter the United States on day one as an employment-based permanent resident of the United States. Right. Good for them. When it comes to the law, I'd say, there's no, when it comes to pendency of what you can do during the pendency of an I-485, there's no, not to my knowledge, nowhere in the law that says you must have a job offer. You must be employed every day in the United States while your I-485 is pending. Yes. There's the process, the portability process, it's not explicitly stated, but it's kind of implicit in that you might change jobs, and thereby there has to be some sort of break in time where you don't have an offer of permanent employment in your hand, or at least on file with the government. But it contemplates a scenario that your I-485 sponsor goes under. Well, as long as you meet the portability requirements, you can, move to another job.
Now,
yeah,
I agree 100%.
Okay,
but I'm just trying to kind of look at it from a different angle.
Okay.
Do you recall the blurb in the October visa bulletin frequently asked question?
Oh yeah. So yeah. Oh, I definitely. Believe me, I was saving that one, Sam.
Okay.
So
all right.
In the, I'm going to see if I can find it right now. Employment-based adjustment.
FAQ USCIS.
Adjustment of status FAQ USCIS.
October, right?
Here it is from October 2023, and I'm going to open all these, and I'm going to say unemployed. Here we are. Amongst the questions that USCIS answered as part of a I-45 employment-based FAQs is, would a period of unemployment while my application is pending affect my eligibility for adjustment of status? And what they say is, a period of employment in an occupational classification different from the prospective job, or a period of unemployment, may affect a non-citizen's current immigration status and could raise doubts about the continued validity of the job offer and or the non-citizen's intent to accept the offered position after adjustment.
So, in response to our friend's question about, can I leave for 4 years? So I want to bring it back to full focus so people understand. And I want to spend time on this.
It's a very good question.
It's a fantastic question. Can I leave for 4 years and come back? The policies did not address that on point, because you can never address anything on point. I don't think there was a 5-year advanced parole at the time they published this.
Yeah.
Talks about periods of working in a different classification.
Yep.
Or period of unemployment.
Yep.
Okay? Now, Explorer Dreamer saying 4 years abroad. Now,
That was considered unemployment. That's in my book. In my book, I would make that argument.
well, you can make the
From the
argument.
perspective of USCIS, I think it would.
Well, you can make the argument, but you can also make the counter argument that he is or she is working within the work that is subject to the green card application, but be it abroad.
But you're assuming they're still with the same employer, because in that scenario, Sam, Explorer Dreamer dropped a nice, hypothetical fact on us. I'll just give them a supplement J, whenever I'm ready for whatever my priority date's current anyway,
Right.
which is a great point right there.
But that could be a basis for an adjustment of status denial. But you have an advanced parole now. You're allowed to leave. You were given permission to leave for 4 years, for 5 years. Explicit permission.
There's no limit on how long.
It doesn't say,
come back,
leave for 5 months at a time. It doesn't say anything.
And because you bring up things like 5 months at a time, because permanent residents can abandon their permanent residence by staying outside the United States for a certain threshold amount of times. And those things don't apply to people who aren't permanent residents.
Right. So what's your conclusion about the statement in that frequently asked question? Do you read into it that they wouldn't be looking favorably at something like that?
Yes.
Yes. So that's a good answer. I agree with you. The answer is yes. But how unfavorably and what is the attitude is hard to tell.
Yeah.
I would find,
as an attorney, I don't want anybody to be in that scenario where they've left for 4 years and come back and USCIS, they're at an interview and USCIS is going, you were left in the United States, you don't have a job.
For 4 years.
4 years. But
this case is going to a manager 100%.
Yeah, I would love to have that argument with the government, and it begins and ends here. It's point me to the policy that says, the law, the regulation, the policy that says this person has to be in the United States the entire, pendency of this thing.
But you would never recommend. I mean, that is after the fact.
Yeah.
Somebody comes to you, hey, I've been outside the country for 4 years. Help me out.
Yeah.
That's different than, hey, can I leave for 4 years? Are you comfortable?
Indeed. I sincerely hope I never. Even though I am. As an attorney, it makes me want to just, tie the government officer into a pretzel knot. If they ever raise this issue, I would never
make the
recommendation because most of the time, for immigration, you want your case to be as normal as possible. You don't want to draw scrutiny. You want your case to look like the last one they approved and the next one they're going to approve.
Part B, would you recommend switching to consular processing? I would begin by asking, you're giving up a lot.
Well, you're giving up a pending I-40. I mean, that seems suggests...
And an ability to do AC-21, changing employers, because who knows 5 years from now whether your employer is going to be around or even interested in you. You're giving that up.
Yeah, you're right. I mean, consular so there's no portability for consular processing.
How about...
There's no portability for consular processing.
No, there isn't.
Yeah.
How about... Let me go for the adjustment interview. If they give me a hard time, I'll just withdraw, leave the country, and file consular processing then.
It sounds like a great idea. It sounds like Sam the scientist put on his lab coat and said, "Well, I've done I've run the math, and this is what you can do." I would say if they.
No, I'm just saying scenario.
Well,
so I'm taking a risk.
Yeah.
I'm leaving. I'm taking a risk for 4 years. I'm gonna come back to the officer and say, "Yeah, here's my employer. Here's a letter. Absolutely, they're gonna take me back. Absolutely, they have a job for me. Yes, I've been outside the country for 4 years." And if you don't like it, and if it's really a big problem for you, I'll withdraw the application and go with consular processing.
Consular processing, just to get them to start that process, years, just get an I-824 processed, and to actually get to the interview, another, good chunk of time on top of that.
Another option.
Yeah?
How about I start consular processing right now without withdrawing the adjustment of status?
Yeah. All these things are possible.
So USCIS hates it when you do that because you're keeping two agencies busy, but there's no law against it.
Yeah.
There's absolutely no law against it. And as a matter of fact, I would recommend it. I would say if you have to leave the country for 4 years, start the consular processing now. Keep the adjustment status, because 18 months from now, you may change your mind.
Yeah.
And you still have that adjustment status. If he's not going to get his green card for 8 years or 7 years, who knows?
Yeah.
You know?
I would fundamentally, challenge the premise. I don't think it's a good idea to, if you're planning to go for that U.S. green card, if you're planning to become a permanent resident of the United States, treat yourself like somebody who is going to become a permanent resident of the United States and reside in the United States.
Having said that, and the client told you, Brian, I understand your sentiment.
Yeah.
I get it.
Yeah.
Now, I'm leaving.
Yeah.
What's my best scenario?
What Sam said. Yeah.
Probably start with an action
Yeah.
on approval. Start the consular processing.
Plan before. I mean, talk with your employer. Guys, I'm leaving for 4 years.
But don't withdraw the adjustment.
Oh no, not at all. Don't give up anything at all.
Okay.
Concede nothing.
Okay. All right. I think we beat that one to death.
Yeah, it's a complex and interesting scenario for sure.
Yeah.
So Explorer Dreamer had another question here, which is a good one. For all India EB2 and EB3 485 pending folks, how difficult is it to convert EB1A self-petition? How many cases is your firm handling like this, specifically from India EB2, EB3?
So we can't give out numbers because that's one thing that we don't give out. However, the approval are some of the cases. I mean, the one where you get today or yesterday was quite shocking because we didn't believe.
I believed in that case.
You believed in that case.
Yeah.
So I mean, it was kind of sketchy. The client wanted to go through it, and it was approved.
Yeah.
So I think there is absolutely opportunity to evaluate if you qualify. Not everybody qualifies, but if you qualify, I mean, the appetite to approve those cases is pretty high. Right now.
I mean, there are people out there. When I talk to them, I say, why haven't you already applied for one? I start hearing about people in academia, people with patents to their name, people who are responsible for really cool products. People who are working for companies that everybody has heard of. When I start hearing things like that, I want to talk with them about the EB1A criteria.
Yeah, and a lot of them, surprisingly, will meet the 3 prongs.
Yeah, I mean, it's not just EB1As. We've helped a fair amount of clients, convert to EB1Cs. People who work for international companies. It's hey, I'm going to be leaving the. I talked with the president. I talked with the CEO. They're going to send me abroad to become a manager for a year. They're going to bring me back as a manager. That puts them on the path to EB1C. It's doable. I was a gentleman who I know we're working on it for right now, and I have another person who we've done it for in the last year or so. Takes a company to stand by you, but Sam, Explorer Dream and propose a scenario. I'm going to go outside the United States for 4 years. If you're going to work for your same employer, the same employer that's sponsoring your green card now, you have a good relationship. They make you a manager abroad, bring you back as a manager. Come back
a year later and
Yeah.
come back on EB1C.
Yeah.
Excellent point.
Yeah. So, a question here from Coach Ron.
I traveled outside the United States with pending advance parole renewal and current advance parole expired. Okay?
Mm-hmm.
Enter the United States on H-1B. My advance parole is still pending for 7 months. Shall I reapply or wait for a decision?
So it sounds like
Expired abroad.
Renewal was pending and AP was expired. So it sounds like they are going to be soon making a decision in the negative on this individual's advance parole. And I see no problem with applying again. Apply early because
the sooner, plus there's no filing fee.
Yeah. If they don't want the case though, they will send you an RFE. But again, there's no filing fee. You're not even going to be out money for it.
I would wonder even if withdrawing the previous one.
You can. That's what I worry
So
about.
you have a cleaner case.
Yeah.
And not worry about all this. I mean, as it is, the delay is atrocious.
Yeah, it is cartoonishly long, the AP processing times, for sure. Another I-131 question from Venkat. Our I-131 AP renewal applications will be delivered to USCIS tomorrow morning, and I have a planned international travel day after tomorrow morning. Part 2. Is it okay for us to travel a day after submitting our AP I-131 renewal application? So,
So I'm assuming you have a valid advance parole in hand.
Yeah, that's the assumption I'm.
So that's very clear, because if you don't have one, you have to have a valid H-1B. And if you don't have a valid H-1B or L visa, then you're definitely risking a abandonment of the adjustment status.
I guess to sum it up, it's if you don't have a valid AP, they're going to deny that renewal application no matter when you leave the United States, as long as it's pending. Yeah, and it's not well. You do have to be physically present in the United States to file for advance parole. But fundamentally, as long as your case is filed, you don't have to have the receipt notice in hand. They log when they get cases. They have a decent mailroom system where they will say, okay, they'll eventually send you a receipt notice that says, we got your case on 11/28/2023, and that's that.
Many years ago, they were sued over that issue. So they were logging receipt date a week or two after they actually received them, and then they were sued, and they now understand that the day it's in their office, not the day they open the envelope, is the day that they will put in as a date for the receipt. All right, sounds good. So let's take the next one, Brian.
Yes.
Fahad Khan.
Yes.
My EB2 rest of the world case was current until March 2023, but it got retrogressed, and now my priority date is not current. I also moved to a different state. How would my case be processed under the NBC adjudicate my case?
Okay. Well, first off,
yeah.
I haven't made this public service announcement. Update your address with USCIS. Anybody who's not a citizen of the United States is required to update USCIS of their change of address within 10 days of it occurring. You can find that on the USCIS website. Do a Google search for USCIS form AR Alpha Roger 11, and you can file your change of address online with USCIS. You must do it.
Yes, thank you. Excellent point. Now, I'm curious. I mean, the change of location is not that. They're not going to move the case around, especially with an 18 months processing time.
Yeah, I'm not inclined to think they're going to move the case around.
That will be anybody's worst nightmare, especially if you're in a job that's every 3 months you're moving somewhere.
Yeah.
In this case, will never get adjudicated.
Yeah, I wouldn't think it's likely for them to move the case based upon a move that Fahad Khan makes. I think it's more likely for them to move it to if they want to interview him, for example, move the case to wherever he is when they want to do that. You know?
Yeah, since it's retrogressed,
yeah.
It is sitting collecting dust in a warehouse until it becomes current. Then it will be pulled, and then they will figure things out.
How will the NBC, Sam, know that he is current?
Well, they have an amazing system.
Do they?
Yeah, called the client reminding them.
Yeah, that's the answer I was fishing for over the pond of Sam. Basically, I would always encourage somebody, if your priority date has not been current, then it once again is, send USCIS a letter, ring the bell, and let them know, because sometimes it can take them a while to figure it out, a very long time to figure it out. Yeah. And it's only in your interest to remind them if your priority date becomes current.
Yes.
Yeah.
Rami Love. Hi, Sam and Brian. What are the chances for EB3 India, August 2012, dates for filing, in January visa bulletin?
So accepting, I see. Man, if you look at the EB3 India dates for filing, they are in August 2012, so it's basically August 1st, 2012. I think it's maybe a question of, are they going to accept the dates for filing for the month of January?
Oh, how would they switch to a dates for filing, accepting dates for filing?
Yeah.
Okay, I understand the question now.
Yeah,
so USCIS changing what date, because they're taking final action date now?
No, they're taking dates for filing.
So continuing to accept date for filing.
Yeah.
Well, but why is that relevant? I mean, if you're August now, you're filing your case now, there's no process.
Maybe somebody's anticipating a perm approval in January, for example.
With a prior visa bulletin.
Yeah.
is it going to continue? It's there. There is absolutely no predictability into which way they go on a month-to-month basis that I'm aware of.
Yeah, I mean, well, generally speaking, at the beginning of the fiscal year, October, it's a pretty good chance,
Yes.
and then all bets are off. Okay, for the next month, I think the more you get into the fiscal year, the more likely they're going to switch to final action dates, and that's the best we can really say on that front.
Yeah. That sounds reasonable.
All right.
You're chuckling.
Explorer Dreamer, continuation of that long AP question. Many Indians, like close to 40,000, 45 applications pending with USCIS. Many Indians would do 4 years in India and return to the U.S. if that's valid.
Sad, because the reality is, it doesn't seem to me that there is a satisfying professional and life opportunity in the United States for many people who are going through the hell experience of the green card application right now.
No, I understand that sentiment. I mean, I talk to a lot of people, and I go to a lot of green card interviews. You do as well, and I'm always in the waiting room and say, well, guys, what are your plans? For buy a house. Really kind of pick a spot I like in this country. Usually it's still the place where they're doing the interview at, but buy a house here. I've been skittish on the subject because I don't really know what my long-term prospects here until there's a green card in my hand. So it's something I sympathize with for sure. So from Sunny.
Hello, my husband has approved I-140 in EB1A category with priority date of December 2022. But as EB1 for India is in retrogression, we see that it will take years to get to the advanced parole or to the green card. Is there a follow-up question?
Oh, there we are.
Is this scenario, he need to visit India and get visa stamped? He is on O1 visa, so he is worrying, will he get into trouble if he go for stamping?
Well, husband on an O1 visa sounds like a pretty fancy guy. As a aside here, is it advisable to go for visa stamping? So,
I don't see on the face of it, absent any additional information, that I would be worried about an O1 visa stamp.
Fundamentally, somebody's paranoid though. The idea that there's no guarantee that I'm going to be allowed to enter the United States, at all. Will I, if we leave, are we going to be able to come back? Because, well, we have a nice life here, prospects of a EB1 green card in the next couple of years. That sounds great. But I have to agree with you. I'm generally not, hearing anything that says, there's a problem. O1 visas, they're usually pretty darn impressive people. I can only imagine that, O1, EB1, that, your husband's out there doing some pretty important work in this country in order to get that non-immigrant status as well as the EB1A green card. What causes problems for people at the consulate? If the consulate thinks that something in your visa application, your visa petition, your O1 petition with USCIS that doesn't match up with what's in your visa application, your DS-160, or that the person that they meet in person doesn't align with what they see on paper.
So what you're asking is what is the source of your worries?
Yeah.
Explain why you're worried. Are you generally worried with no foundation, or is there more to that worry that you have that you should share probably with a qualified attorney that can help you address that specific worry based on first specific scenario?
Yeah. Fundamentally, if at some point, you would have had to go to presumably the consulate and get an O1 visa. Maybe not. Maybe it's just somebody who came as a student, for example, and changed to O1 status. But out of curiosity, Sam, let's here are your options: applying for a student visa based upon or applying for an O1 visa based on unapproved O1 petition. If you're going to the consulate,
it's a no-brainer. O1.
O1, yeah, it's an O1 visa stamping application comes with hundreds, if not thousands, of pages of paperwork to USCIS saying this person's an O1 person. USCIS has already approved it. You go into the consulate just so the consulate can make sure what they see in the person, what they see in the visa application they get aligns with what is in that that petition that USCIS has already approved. Whereas so many other types of visas are, well, a student visa, for example, a lot harder to pass that appointment versus somebody with an approved O1 petition, I would say.
Yeah, absolutely.
Yeah.
So, well, congratulations on the EB1 I-140. It's commendable, but obviously there is a little bit of delay, and I think your prospect of getting the green card is 10 times better than 99% of the people out there. So.
Yeah, I mean,
so that's not bad at all.
Yeah, I mean, the priority date for EB1 dates for filing EB1 India are in July of 2019. That's okay, a couple years off, about 3 years off. But it seems reasonable if USCIS keeps that trend of accepting dates for filing in the beginning of fiscal years, maybe 2 or 3 fiscal years, you could find yourself with a current priority date in October visa bulletin, or dates for filing anyway.
Yep.
Yeah.
Well, I think we got to everybody, Brian.
Yes.
I hope so.
We have any additional? Got one.
Mr. Khan has a comment. Let's take it.
Yeah.
Would you expect any forward movement in EB2 rest of the world in January, given the expected catch-up to the dates of filing? The answer, I think, is we do, because they are holding back some numbers.
Yeah.
They told us.
They have said, I think it's on the October visa bulletin, or maybe the November one, saying, hey, our movement on this reflects, keeping in line with our quarterly visa limitations. And when that January visa bulletin comes, I think which we expect to be a late one, because the more interesting ones tend to come later in the month, and we will see then. And I suspect that we will be here talking about the January visa bulletin
very soon.
Some Monday, some 6 o'clock, sometime in mid to late December, because it's what we do here.
Yep, absolutely. And with that, we conclude today's session. Thank you guys for listening to us, and best of the luck. Have a wonderful rest of the week, and we'll see you Monday at 6 o'clock back here with another interesting topic.